Okay, jury, I am advised that you have reached a verdict, and the clerk of the court will now accept the verdict. We'll have the foreperson please rise.
Has the jury agreed upon a verdict?
Yes, we have.
What is your verdict, please?
We, the jury, find the defendant guilty of first-degree premeditated murder. We, the jury, find the defendant guilty of first-degree felony murder.
Members of the jury, listen to your verdict as recorded. In regards to count 1, guilty of first-degree premeditated murder. Count 2, guilty of first-degree felony murder. Is this the verdict of the foreperson?
Yes, it is.
Is this the verdict of the jury?
Yes, it is.
Okay, you can have a seat, sir. We're going to poll the jury now.
If you could pass the microphone to juror in seat number 1, please. Juror in seat number 1, is this your verdict?
Yes.
Juror in seat number 2, is this your verdict?
Yes, it is.
Juror in seat number 3, is this your verdict?
Yes, it is.
Juror in seat number 4, is this your verdict?
Yes, it is.
Juror in seat number 6, is this your verdict?
Yes, it is.
Juror in seat number 15, is this your verdict?
Yes, it is.
Juror in seat number 14, is this your verdict?
Yes.
Juror in seat number 13, is this your verdict?
Yes.
Juror in seat number 12, is this your verdict?
Yes.
Juror in seat number 11, is this your verdict?
Yes.
Juror in seat number 10, is this your verdict?
Yes.
Juror in seat number 8, is this your verdict?
Yes.
Thank you. Counsel, if you can approach to review the verdict form, please. Does this comport with the verdict we just received in open court? Yes. Comport? Okay. I've now received the verdict and confirmed that it comports with the verdict received in open court and confirmed by polling. So, verdict having been received, I now thank you for your service. This was a very significant and time-consuming case. We were worried we would not get a jury to stay through it all and work through it all, and it was a lot of work. I've never had a jury ask as many questions as you did. So on behalf of all of us here, I want to thank you for a job well done as far as listening to the evidence and paying attention to everything, and taking the serious time to deliberate the case as well. So thank you, and we're going to have everyone here wait in the courtroom a bit. I'm told the jurors want to get out of here and go, so we'll stay in the courtroom and give you guys the space to get out of the building, and thank you. And you're done. You can watch the Yeah. Okay, counsel will need to schedule a sentencing date. Mr. Mueller and Mr. Cowley, I have late morning, May 12. I generally do them on Mondays, and Monday mornings. So I'll throw out some dates. I have May 12th, late morning. May 19th, all morning is open at this time. Or May 27th.
Your Honor, I can't do May 27. We're at the drug
okay.
treatment training, so I prefer, and I would like to be here.
Do the other dates work for you?
Yes.
Okay.
What was the second day, Your Honor?
I think the second option was May 19th.
Your Honor, we're both good for May 19th.
Okay, do you want later in the morning?
That'd be good.
Okay,
Like 11-ish.
okay. Okay, counsel, anyone on bond? I'm inclined to revoke bond at this time.
It has to be by
Okay.
statute, Your Honor.
So I will revoke bond due to the conviction, the murder conviction. So Ms. Sturmer, I'll have you go with the jailers to the jail. And counsel, we would have you two sign a stipulation for return of exhibits
We've
to
already
both
signed it,
sides.
Your Honor.
Oh, okay.
Thank you. Ms. Winkler was
Anything else then, counsel,
No, Your Honor.
No, Your Honor.
to address now? Okay. Okay, thank you. Yeah, for sure.
Thank you. This time, the clerk, please read the verdicts.
In the Superior Court of the State of California, County of Los Angeles, in Department 101, the people of the State of California versus Monica Cementelli, in case number BA 452-97502. We, the jury, in the above entitled action, find the defendant, Monica Cementelli, guilty of the crime of murder in violation of Penal Code Section 187A, a felony as charged in count 1 of the indictment. We further find the murder to be of the first degree. We further find the allegation that the murder of Fabio Cementelli was intentional and carried out by the defendant, Monica Cementelli, for financial gain within the meaning of Penal Code Section 190.2A1 to be true. We further find the allegation that the defendant, Monica Cementelli, intentionally killed the victim by means of lying in wait within the meaning of Penal Code Section 190.2A15 to be true. Dated April 11th, 2025, juror seat number 10, foreperson. In the same case, title, and cause, we, the jury, in the above entitled action, find the defendant, Monica Cementelli, guilty of the crime of conspiracy to commit murder in violation of Penal Code Section 182A1, a felony as charged in count 2 of the indictment. Dated April 11th, 2025, juror number 10, foreperson. Ladies and gentlemen of the jury, are these your verdicts? So say you one, so say you all.
Yes. Does the defense of the jury poll?
Yes, please, Your Honor.
Please poll the jury.
Ladies and gentlemen of the jury, as I call your seat number, please answer yes or no to the question. Juror in seat number 1, are these your verdicts?
Yes.
Juror in seat number 2?
Yes.
Juror in seat number 3?
Yes.
Juror in seat number 4?
Yes.
Juror in seat number 5?
Yes.
Juror in seat number 6?
Yes.
Juror in seat number 7?
Yes.
Juror in seat number 8?
Yes.
Juror in seat number 9?
Yes.
Juror in seat number 10?
Yes.
Juror in seat number 11?
Yes.
And juror in seat number 12.
Yes.
The jury has been polled, the verdicts are ordered recorded. Both sides waive reading of the verdicts as recorded by the people
Yes.
and the defense.
Yes.
Your service now comes to an end. A couple things I need to tell you. First is my thanks. You made a tremendous sacrifice. We've been together for a long time. You are the backbone of this democracy, and for that, you have my endearing thanks. Next, the admonition I've given you many times is now lifted. You are free to discuss this case with anyone you so choose. You don't have to talk to anybody if you don't want to. This is up to you. The lawyers may want to talk to you. It's up to you whether you want to talk to the lawyers. If there is any misconduct, by the way, anyone approaches you, I want to hear about it. Next, all identifying information about yourselves is ordered sealed. It cannot be unsealed without an order by me, which I cannot do without notice to you. I hope your service before me wasn't too unpleasant, because I'm going to see you again soon. You're now discharged. The jury assembly will sign out. Thank you so much. Make room for the jury. The jury and officer now at the courtroom. Mr. Lean, when do you have sentencing?
Could we request a date from the end of June?
Yes. What's a good date? Any day is good. I'm waiting for a good date.
Sorry. G26, you want?
How's that with the people?
May I have a moment?
Sure.
Did you say the 26th, counsel?
Yes.
Is it possible to do it on a Monday or a Tuesday?
24th?
Judge, we have an evidentiary hearing on the
Sorry?
24th. We have an evidentiary hearing on the 24th.
23rd, Your Honor, would be fine.
Yeah, the 23rd would be better. Is that what that does?
Better.
How's the 23rd?
But
Does that agree with you, ma'am? Matters, came for sentencing June 23, 2025, 8:30 a.m. in this court. Defense remand was up.
Yes. We told them.
Thank you. I do not think juvenile sanctions or youthful offender sanctions are appropriate under these circumstances. His actions are egregious, and the victim in this case is lucky to be alive under these circumstances. State, did you want, I am going to sentence him to prison, followed by a lengthy term of sex offender probation. I don't know if you want to be heard as far as conditions now or after I impose the DOC sentence.
I believe the standard sex offender conditions would be sufficient. That would include treatment and as well as no contact or internet use without the risk assessment. So I believe that would encompass everything that's needed.
Okay, so once I announce my sentence, if there's something additional either side thinks that I should address, I'll be glad to do that. All right, Mr. Stone, this is unfortunate for you, for the victim, for both of your families. I'm going to start with count 2. It's a burglary of a dwelling with a battery, which is punishable by up to life in prison. You're adjudicated guilty and sentenced to 25 years in the Department of Corrections. That's going to be followed by 30 years of sex offender probation. You're going to have to follow the sex offender probation conditions set forth in 948.30, which includes sex offender treatment, a variety of other things, including polygraphs, no use of the internet without a risk assessment, no contact with children under the age of 18. I don't know that that's going to be applicable in this case, but I assume all those are still going to apply. You cannot have any contact with the victim in this case, which means that no phone contact, third-party contact, no contact in any manner whatsoever, no electronic contact, no writing. You can't go within 500 feet of where she's living, and you can't go within 100 feet of a vehicle that she's in, and that will be during the entirety of your DOC sentence and the probation. You're going to have to register. It is a sex offender, right? Not sex predator?
I believe it's sex offender due to the nature of count 1.
Okay. You are going to have to register as a sex offender pursuant to 943.0435. Let me address count 1 now before I continue, because the conditions are going to be the same. On count 1, which is a sexual battery, you are adjudicated guilty. You're sentenced to a term of consecutive probation to the prison sentence on count 2. So it's 25 years in the Department of Corrections, followed by 30 years of sex offender probation. The probation on count 1 is for 15 years of sex offender probation, concurrent with the 30-year sex offender probation sentence on count 2, which includes all the conditions of sex offender probation outlined in 948.30, including the no contact provision that I just announced, will be applicable to both counts. Additionally, you do have to register as a sexual offender pursuant to 943.0435 for both counts. Additionally, you must complete a mental health evaluation. You must make arrangements to have the mental health evaluation within 60 days of your release from the Department of Corrections. Thereafter, you must comply with any recommended treatment or counseling. You must also enroll in an anger management course within 60 days of your release from the Department of Corrections, and you must successfully complete it on the first attempt. Once again, you're not to have any contact with the victim. It relates to both counts. On each, actually on count 2, you're going to receive credit time served in the amount of 237 days. There's a $500 fine plus mandatory court cost, $100 cost of prosecution, $100 cost of defense, $50 public defender application fee, and you must provide a DNA sample for the FDLE database. As I said, the DOC sentence of 25 years is followed by consecutive sex offender probation on count 1 and count 2. So, what do I need to address as far as conditions of probation from the state's perspective?
I would request that the court add that the defendant must comply with all registration requirements as a sexual offender as a condition of the probation.
Okay. And I announce the statute, but you must comply with all sex offender reporting requirements pursuant to statute. And that will be applicable to count 1, the 15 years, and count 2, the 30 years following the DOC. Mr. Mills, what else do I need to address related to any conditions of probation or the conditions of the sentence?
Nothing further from the defense, Your Honor.
Okay. You do have 30 days to appeal. All right, is there anything else that needs to be addressed?
No, Your Honor.
Mr. Mills, did you want the evaluation of Dr. Williamson in the court file?
Yes, please, Your Honor.
Because I wasn't sure if it had been filed yet.
Right, thank you. That
All
would
right.
be perfect.
And for the record, I provided the court the score sheet in advance.
Yes, and I have the score sheet here, and I know Mr. Mills referenced the lowest permissible, which was reflected in the score sheet that I had. You're more than welcome to review it, Mr. Mills, if you want to.
No, thank you, Your Honor.
See it?
We didn't have an objection to it.
Okay. Okay.
Thank you, Your Honor. May I be excused?
Yes, ma'am.
Here. I sat in this trial. I picked up this case. I started down here July 1. I picked up this case, and I did the motion for motion in limine. And I know exactly what I wrote and what I ruled. You can't use other crimes or acts to show bad character or propensity. There has to be clear and convincing. But it doesn't negate the fact, just because I didn't use that event, it occurred. And it was with two people there. It was with Mr. Nix and Mrs. Nix. And when I hear today situations and testimony about where the seat was put in the driver's side because Kaylee and Nix did it, not Mrs. Nix, Miss Tracy Nix, the defendant, did it, that's inconsistent with the deposition testimony that Kaylee Nix said, and it's also inconsistent with what she wrote in her victim impact statement. Then I listened to her testimony about the juror was sleepy and gave a bottle and immediately fell asleep. And there's a video, and I don't recall seeing that. But I also recall in the trial, they talked about giving the baby a straw and some water in a straw, and that this was a situation where their baby didn't have food and milk. And I went through, and I'm going to come down to this in a minute, but the evidence that comes in, I wasn't there, you weren't there. The only people that were there were Miss Nix, and at the time, we get evidence after the fact, and when we're sitting in the room and we're watching it, it comes in. Like, here's the back seat of the car, evidence 41 that came in. Here's the front seat of the vehicle, 40, where there's wipes and things in a car. And when people go places with kids, they leave objects, thread on the steering wheel, things in the front seat to remind them where they had a child. And I'm not talking about a child that was there, you had an hour-long, 2-hour-long drive. I'm talking a 7 to 9 minute drive. Here's the exhibit 29. It's the back seat of the car. There's evidence everywhere. Then we see the picture of when Nay and them got there. That's evidence 23. I then have a half-empty thing, a bottle, evidence 35. So I see all of that, and I see all the reminders, and then I remember Kaylee and Nix saying that the Lexus, the red Lexus, was equipped with a red rear occupant alert to alert an adult to a child in the back seat. And I know that these cars, Fords, Lexuses, everything has so much weight in the back seat, beep beeps go off. And I hear her saying I didn't have that. But then I read the deposition taken of Kaylee and Nix, docket entry 201, October 1, 24. Do you know who put the car seat, page 32, line 5 to 7? Do you know who put the car seat into the car that day she picked a Euro up at the glass shop? I do not. I do know it was her tendency to put the car seat in herself. Okay, Kaylee answered. She typically, whether I was standing there or not, would pick her up and set her in there. And then I would typically help reach over and strap her in. But a car has sensors, weight sensors. So that, just like my vehicle, whenever I stop and put it in park and turn it off, there's a loud ding that says, check your back seat if there's weight in the seat. And so those are things that I'm aware of that were in a vehicle. So when she put her in there, I do not imagine that I had any other staff assist her in the moment putting her car seat. Did she normally put the car seat behind the passenger or driver's seat? I have her telling me it was in the driver's seat because Kaylee did it, and I have Kaylee saying that it was typically in the driver's seat. And then I have these tendencies and these things that I see that show that there's a baby in the car. And let's not forget that we just left Beefville Brady's. This child was the apple of everyone's eye there. I've been to the Beefville Brady's. I've had lunch there. There's a lengthy video. There's a video of the car in the parking lot. At the end of the day, Kaylee Ashok presented this evidence to me through her testimony, her victim impact statement, and her the deposition. The defense has presented to me the witnesses and the evidence. What I know for a fact is Tracy Nix left Euro in the car at 2 p.m. for over 3 hours. At no time during the 10,800 seconds that elapsed did she think 1 second about her granddaughter. Uriel Shock was there for 2.5 hours with her that day, and she just saw her 7 to 9 minutes before, and then she goes to the residence 7 to 9 minutes away. This child, like I said earlier, was the apple of everybody's eye. It captivated, entertained the patrons and the people at Beef O'Brady's, much like a 7-month-old does, a year-old does, a 2-year-old, a 3-year-old does. You know what you're doing with them, and in 7 to 9 minutes, by golly, you know where that child is. And anything to the contrary, and any excuse to the contrary, is just that. I heard and saw the body cam footage along with the interrogation room video of Tracy Nix immediately discovering what happened after she has a grandchild passed away. She was distraught. I don't believe there's a lot of remorse in that about her grandchild suffering and death. Rather, I see her more concerned with her community image and the death of the child. I want to leave. I want to go away. I want to do this. I want to do this. I want to do this. And I hear today the evidence and the testimony, and I get a little more remorse on that, but is it truly remorse?
Yes.
Tracy Nix, throughout these proceedings, has contended these acts were involuntary. She couldn't form the requisite intent to commit a crime. Her narrative is that she forgot because of senility or by taking her prescribed mind-altering medications. There's no credible evidence to the court that's persuaded this court to mitigate her sentence as the attorneys have requested. This defendant, like many other defendants facing prison sanctions before, is trying to avoid or lessen a prison sentence once arrested and after a jury finds them guilty. They justify what happened rather than accepting blame and truly evidencing remorse. I have practiced law for 30 years. I've sat on this bench for over 3.5 years. I've met my share of people in the Florida state prison system, the federal system, and I understand that they minimize their conduct and they also don't accept responsibility. And that's how it is. And there's a pile of them down at Hardy Correctional that'll tell you the same stories that I heard here today. The ultimate determination of when we do a case, and I excluded the evidence of the experts on the defense side. It's when you look at whether a defendant is competent to proceed, it's my determination in state court, in a trial court. Under the Dougherty v. State case, 149 Southern 3rd, 672 at 678, the trial court is not bound by the reports or opinion of experts. The defense in this case never afforded nor volunteered Tracy Nix to the state of Florida to have her evaluated by its own experts, so the state of Florida, the citizens of Florida, were denied the right to contest the evaluation and procedures and conclusions of the Tracy Nix retained, hired experts. They all say we're here for our time. They come in here, they get paid, they give their opinion. They give their opinion. If it's valid for the defense, they testify. If it's not valid for the defense, they don't testify. I heard this man's testimony. In a competency or an insanity case, the state has the right to contest the evaluation procedures and the conclusions of the court-appointed experts. Had she alleged incompetency or not guilty by reason of insanity, the state of Florida and all the citizens would have the ability, the state would have had the ability to hire its own experts to evaluate her mental and physical claims. The state was not afforded that here. And that's why we have a 35-year-old law that says you can't bring in diminished capacity. I ruled on that. I'm not going to revisit that ruling. The state, as a representative body for the citizens of Florida, has a right to a fair determination and meaningful opportunity to be heard to conduct its own review of Tracy Nix. All of her defense experts were hired for their time and to defend her. They had unbridled access to her so they could present their opinions to the court. What I noticed was there was no, what did the MRI findings say? I don't know. I wasn't given that. There are many tests that mental health experts can perform and routinely do perform on criminal defendants to determine if a criminal defendant is falsifying or exaggerating facts or symptoms. There's called malingering. There's no medical records nor testimony presented to this court that she suffers from Alzheimer's, dementia, or senility November 1 of 2022. None of the defense experts have testified they tested Tracy Nix for malingering or confabulation. They simply say, trust us, we are experts. The court declines to do that. In Florida, the term for imprisonment for a second-degree felony is up to 15 years in prison. First degree is up to 30 years. Life is up to a defendant's life. And in a capital case, I can sentence somebody to death if the aggravating factors exceed the mitigating factors. In this case, Tracy Nix has been found guilty of a third-degree felony, punishable by a maximum of 5 years in Florida State Prison. On January 15, 2025, a jury found the defendant guilty of one count of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm, but in reality causing death, and not guilty of one count of aggravated manslaughter. I've already gone over what I talked about with the Rule 3.704D9 about the victim injury points. Her score sheet is 44 points. Under Florida law, the maximum sentence I can impose for Tracy Nix is 60 months or 5 years in Florida State Prison. For me, as a trial court, to impose a departure sentence, it's a two-step process under Banks v. State. 732 Southern 2nd 1065 1067. First, I must determine whether I can depart. That is, whether a legal basis exists for the departure sentence that has been established by a preponderance of the evidence. 2, even if a valid and supported legal ground exists to permit a departure sentence, the trial court must still determine whether it should depart and whether a departure sentence is the best sentencing option in a given case. 2 facts the defense argued in their motion to mitigate. 9, that Tracy cooperated with the state of Florida to resolve the offenses she was charged with on November 1, 2022. The court finds that not to be the case here. Tracy Nix did not cooperate. There's no competent substantial evidence that the crime she was charged with was resolved as a result of her cooperation. To the contrary, she investigated it, she went to trial, she didn't enter a plea to count 2, and she didn't cooperate with law enforcement or the state prosecutor. The second ground they sought mitigation is 10, which is an unsophisticated, isolated incident. There's 3 elements that must be proven by the defendant when you raise that mitigation, not 1 or 2. Number 1, Tracy Nix has to prove to the court that the offense was committed in an unsophisticated manner. Number 2, it was an isolated incident, and she has shown remorse. All 3 elements have to be proved. You can't prove 1 or 2, all 3. Tracy Nix and her husband had the 17-month Ezra at their home, who died 11 months earlier. That is a fact. That came in every hearing I've been in, and I've heard it today as well. The grandchild Uriel Shock's tragedy is not an isolated incident. This is the second. The court watched and heard her interview. I do not believe she's showing remorse. I believe she's showing sorrow. It is impossible for a defendant who refuses to accept responsibility for an offense to show remorse for that offense. Sympathy is not the same as remorse. Sorrow is not the same as remorse. What I look at in the Florida statutes when I deal with sentencing under 921.02, subsection 1B, the Criminal Punishment Code's primary purpose is to punish an offender. Rehabilitation is subordinate to the goal of punishment. Subsection C, penalty imposed shall be commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. The court does not find that the defendant's sentencing proposal is the best sentencing option. Rather, Tracy Nix should spend the next 60 months in Florida State Prison with credit for time served. The trial court is guided by the code, the sentencing guidelines, and the express purpose for criminal sanctions under Florida law, and a Florida State Prison sentence of 60 months is the best sentencing option. The court also finds that she knew how she was feeling on November 1. The multiple videos, some with audios that day, and the testimony of her Bible study and many friends unequivocally established her awareness that day she is not competent, nor is she insane. She caused aerial shock to suffer an agonizing, prolonged death that was avoidable. The court saw all the evidence in the photos. I want to note the diaper bag that was brought into evidence, Exhibit 36, Exhibit 37, Exhibit 38, Exhibit 39, was the most organized diaper bag I've ever seen in my life. And I heard testimony that the child didn't have food, this, that, and the other thing in the beef O'Brady's, and they fed her through a straw. I note that it was an excellent diaper bag. The bottles, food, medicine, and the items were all in quart bags, Ziploc bags. For witnesses to say or allude that Uriel had no milk, formula, or food is hypocritical and untrue. The court finds such testimony by any such witnesses not credible for sentencing purposes. The defense's recitation of their mitigating factors without confirmation by any unbiased expert, in addition to the deficiencies the court found earlier, also fails to establish by a preponderance of the evidence any mitigation that is to be considered by the court today, nor do they amount to competent, substantial evidence for this or any court to justify a sentence of less than 5 years in Florida State Prison. The defendant restrained Uriel Shock in a car seat, and the child was severely injured before she died. There were plenty of signs to Tracy Nix that she had a baby in her car that day and she was responsible to protect it. She failed in her protection of Uriel. I will not fail this state or this community in my duties as a judge to fashion a sentence that I feel is appropriate for these type of charges. You can call it whichever one of the 5 points you call it, but I'm calling it a just and determinate sentence based upon the facts and evidence that I have seen here and heard here and presented today. The court hereby sentences Tracy Nix to Florida State Prison for a term of 5 years of Florida or 60 months with credit for all time served. A $5,000 fine shall be reduced to a judgment lien. The cost of prosecution and restitution will be reserved for 60 days. Y'all can agree on it or we'll have another hearing. She will be remanded under the supervision of the Department of Correction until her term of prison ends. Now I'm going to speak to this community. I'm not from here. I'm from Winter Haven, Polk County. This community needs to move past this case and leave Kayla and Drew Shock alone. Let them and their 2 children live in peace. This family has lost 2 children, Ezra Shock and Uriel Shock. The tragedy of this case is undeniable. A baby's life is over way too soon, and a family has been severely impacted in unimaginable ways. Whenever a child dies, this entire community suffers. This community needs to move forward and start the healing process. I have made a final and determination here. I'm not putting people on probation to be walking around this community to rehash an issue or something to come up. I have sentenced her to 5 years in Florida State Prison. I want this community to move forward. The legislature defined this felony crime. A fair and impartial jury found Tracy Nix guilty, and I, as a circuit judge for Hardy County, have sentenced her accordingly. Ms. Nix, you have 30 days to appeal the judgment and conviction of this court. If you cannot afford an attorney, one can be appointed for you without cost for appellate purposes. The state, do you have anything further I need to deal with?
Your Honor, to head off an issue, we'll waive cost of prosecution, so we don't have to have a hearing.
Okay. Do you want to reserve on restitution? If you don't, you can reserve it, and then you can either agree, disagree, or say, Judge, we're not having it, it'll go away on its own.
Your Honor, we can reserve it, and it'll probably go away on its own.
Okay. Mr. Fletcher, anything further we need to go on?
One thing I have to say, as her attorney, May Nix Day, and I think, I don't know if she's still here, Alex Amanda Fletcher, testified there wasn't any car.
I understand. I understand.
Okay, because you said that, I thought you said there was.
You're talking about the car seat?
Obviously, we disagree about the remorse. I'm not going to argue with that. We also have a motion for supersedious bond.
You're absolutely correct. Once you file your notice of appeal, the supersedious bond statute will go into effect. You'll then have a hearing on your motion. but the first event that has to happen is a notice of appeal. Once that's happened, send it to my JA. For your information, Ursula Nathy is my current JA. Next week, my new JA will be Julie Cochran. Her email address will be circulated on the website. It'll be J. Cochran. So file your notice of appeal. You can either reiterate the motion you've already done on supersedious bond or file a new one, and then I'll set a hearing time that's commensurate with both of y'all's calendars. Mr. Coleman and my JA will work with you on that, okay? And if you're not going to handle the appeal and you got a public defender, please get your paperwork in sooner rather than later.
We have an attorney.
Thank you. Court's adjourned.
All right.
And I'm adjudicating her guilty, okay? For the record.
All right, People versus Walker appearances.
Good morning, Your Honor. Dion Benjamin.
And good morning, Your Honor. Kellen Davis for Mr. Walker, who's present in custody.
Good morning.
Good morning, Hillary Williams for the people.
All right, what's your pleasure?
Your Honor, we're asking to proceed with sentencing at this time. Mr. Walker does have a brief statement that he wishes to make, and we wish to address the mild modification to the plea agreement that we've discussed off the record.
Yes, I think counts 3 and 5, the plea agreement talked about 1/3 of the term, but they're going to be concurrent, so it would have to be not 1/3 in the term. Which I think it's 6 on each.
Correct.
Yes, Your Honor.
Have you discussed that with your client?
Yes, Your Honor.
And does he understand the consequences of that?
Yes, Your Honor.
Is that true, Mr. Walker?
Yes, sir.
Okay. You may proceed, Ms. Williams.
Your Honor, I think with respect to the plea agreement and the amendment that was made?
Yes.
Okay, then just for the record, as to page 7 of the plea agreement that was filed on February 5th, 2025, as the court recognized under number 14, consequences of plea and admissions, it does list that line 19, which is with respect to count 5, and line 21 with respect to count 3. I have amended by interlineation the agreement to read that it will be the midterm of each of those counts, which, as the court has indicated, is 6 years as to each count. But again, does not change the time of the sentence, which remains 29 years, because count 5 and count 3 will run concurrent.
Correct. All right. And the court has calculated 16 days actual, the way back time, and two additional days for good time, work time, for a total of 18 days.
Yes, Your Honor.
Yes.
Agree? People agree?
Yes, thank you.
All right. Do either one of you wish to be heard?
Not at this, well, there's
You said
one.
your client had a statement, but do you want to be heard?
On one matter, Your Honor, with respect to the protective order that has been in place on this case for several years, my client, through counsel, has made numerous requests to modify that protective order in order that he could possess the discovery in this case. The court and the people have opposed those requests, and the protective order has remained in effect. And I just want to renew that request and clarify on the record whether the protective order that's preventing Mr. Walker from possessing the discovery of documents in this case, including police reports, remains in effect.
Yes. Okay. Anything else you want to say?
No, thank you, Your Honor. Mr. Walker, other than that, Mr. Walker has a brief statement.
No, Your Honor, before we get to Mr. Walker's statement, one thing that also was included in the plea agreement was his waiver of his appellate rights. In addition, I had spoken to Mr. Jackson, the victim's family, and there were times when Mrs. Jackson was leaning towards perhaps making a victim impact statement, but the amount of time and pain that that family has gone through regarding this case, I think, and they have told me they are going to respectfully decline to make a statement to the court, but I do want the court to know that the devastation that this family has gone through, the impact it has made on their lives, it is really insurmountable. And I've had many conversations over the last 5 years. Mr. Jackson was murdered in February, as the court knows. And we have now, 5 years later, the times I have spoken to them have been very, very difficult for them to process. So I wanted to make that known to you because they are very well aware of the proceedings, have been throughout, and my heart really goes out to them, obviously to the friends and the fans of the victim. So that's coming from me, and I wanted you to know what they've been through.
Yes, I can appreciate that. All right, Tom wants to make a statement?
Yes, please, Your Honor. Thank you.
Sure.
Today, as I, Corey Walker, stand before you in court today for sentencing for my unforgettable consequences, even though the Jackson family isn't here in court today, I would like to sincerely apologize for my unforgivable actions. Although there's no apology that amounts to the taking of one's life, also I would like to take this opportunity to apologize to my family for the pain and embarrassment that they have endured over the last 5 years, as well as an apology to my community. I would like to thank my lawyers for helping me avoid a much more harsher punishment. Today, I take responsibility for my dreadful partake in these crimes, and as I begin my road to rehabilitation, I assure you that I will steer clear from negative behavior. Thank you.
Thank you. All right, anything more?
No, thank you.
All right, I'm ready to consider the probation report. You waiver in the judgment and sentence?
Yes, Your Honor.
Any
Yes.
legal cause?
No legal cause.
Okay, pursuant to the agreement of counsel and defendant, the court sentences the defendant as follows. On count two, the defendant is sentenced to the high term of 9 years, and the court has weighed the aggravating factors that he's admitted against the mitigating factors, and I think the defense stipulated that they agreed that the high term is appropriate based on that. Is that correct?
That's correct.
Okay. In addition thereto, consecutively, the defendant is sentenced to an additional 20 years on the firearm account under 1202.53 C and E consecutively, so that makes a total of 29 years. In addition thereto, the defendant is sentenced to 10 years on the 1202.5 B E, and that's concurrent? No, stayed?
I believe that there was the 10 years that was stayed under the 186.22.
Okay.
Not the 1202.53D.
Oh, okay.
Correct.
Okay, sorry. On count 5, that's the manslaughter count, the defendant is sentenced to the midterm of 6 years concurrent with all of the counts. And on count 3, likewise, he's sentenced to 6 years, which is the midterm concurrent with all of the counts, for a total of 29 years. In addition, he's given credit for he's waived his back time, so he gets credit for the time he served since the plea, which is 16 days, an additional 15%, which is two days, for a total of 18 days credits. He's to submit to giving samples for the DNA, palm and fingerprints, and in addition, what about the restitution fine?
So the actual restitution.
Well, first, the restitution fine. Do you agree that because he's indigent, it should be the minimum?
With respect to fines and fees?
I'm sorry?
Fines and fees, correct?
Right.
Okay.
Yeah.
Yes.
Do I agree that because he's indigent, it should be the minimum? No, I think that he will have the next sentence is 29 years and he can work while he is in prison. I can tell the court that there are, at this point, no actual restitution owed.
Really?
Correct, I'm sorry?
Really?
Yes. There was not a claim for burial services, which we typically see. There has not been a claim for any other restitution to date. And that also was the same with respect to the other co-defendants. So I've advised counsel that should I learn that restitution is being sought, certainly I will review it, speak to counsel, and if in the future I needed to calendar that, we will. I don't anticipate it. You never know.
But the reason I ask is because if I impose more weighty restitution fine, that would compete with actual restitution.
I understand.
So as long as it's in the wings, so to speak, I'm kind of reluctant to impose.
I don't anticipate it. This case has been, I do not anticipate it because this has been going on now for 4.5 years, the case. And like I said, I did handle the co-defendants. They have already been sentenced. And there was not a claim at that time as well.
Your Honor, we would ask the court to stay the fines and fees. Mr. Walker, as the court pointed out, is indigent. He's not paid for any portion of his defense on his own personally, and he has been in custody for nearly 5 years with the inability to earn money. So we'd ask the court in the interest of justice to
He
stay.
will have the opportunity to work in prison.
As we all know, that is a very small sum that can be earned in prison, and I think that the statute requires that the court consider his indigency at the time, and he is indigent at this time.
The statute permits me to consider prison earnings and things like that.
I understand. I think that's speculative at this point, and we would maintain our request that the court stay those fines and fees.
How much would people requesting?
$10,000.
Okay, I'm gonna impose a fine, a restitution fine in the amount of $1,000, like parole revocation fine, and the same amount that'll be stayed pending the successful completion of parole, at which time the stay will become permanent. Anything else?
No, Your Honor. Thank you.
Thank you.
Thank you. Oh, do we have a remaining count to be dismissed?
Oh, you're right.
Count one.
That's correct. All remaining counts and special allegations are, I do ask the court to dismiss that pursuant to the continuing validity of the plea.
Okay.
And Your Honor, Mr. Walker would like to be sent forthwith?
Yes, forthwith. Okay, so ordered. Anything else?
No, Your Honor. Not at this time. Thank you.